let's get to what April's doing. April is challenging it in a different way than Nick is. This is not a Frank's motion. This is actually a different bit of an issue here. And ultimately, guys, remember, the prosecution might need time to respond, or they might go forward. It depends. They've already done a lot of prep on this for Nick's case. So through April's attorney, and this is for her case here, and this is the Candioi County Court, versus April Imholt. Now, what are they arguing? The complaint does not comply with the Minnesota Rules of Criminal Procedure. Now, what are they doing? Well, they are arguing the complaint fails to establish probable cause to believe that April committed an offense. They're also arguing that under the Fifth and Sixth Amendments, they want a dismissal because of for lack of sufficiency, or they want the government to give them a bill of particulars. Now, what's a bill of particulars, chat? A bill of particulars is where the government has to explain what's going on and actually articulate how you committed the crime, if that makes sense. So a bill of particulars doesn't have to say April did this, then she did this, and this, and this, but they have to explain, okay, she possessed the cocaine, we believe, because we could show that credit cards in her name were found with cocaine residue on them, found next to a snort tube full of cocaine, found literally in the room where 26 grams of cocaine were located. They had to explain how they can sustain each charge and how they plan to show each element of the charge. Now, like I said, they don't have to write it out like it's a massive story, but they do show it, and that's what a bill of particulars does. Now, that's actually not an obscene request, getting a bill of particulars. They'll probably grant that. I would assume that gets granted.
You think so?
Yeah,
pretty unusual to get a bill of particulars granted.
I mean, I would say in Ohio you have the right to ask for them under the criminal rules. Yeah, I mean it all depends. I mean, like it's nothing wrong with that. Although the prosecutor may stand up and say, "Look, judge, here it is. Boom, 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 done." And
yeah, exactly. I'll just tell you, like here it is. That's what we saw.
She had cocaine. Yes.
That's what we saw in the Sarah Boone trial, where it's like you're asking for a Boone bill check. Is like, okay.
Yes.
And the prosecutor just gets up like, okay, here's your bill of particulars. I'm just telling you what it is.
Yes. So it all depends. And I will say in the case with April here, they've already done with Nick. So they know the case pretty well because they had to write a massive motion to respond to Nick.
Yeah. Now, but what is real critical to me is not only is she not following the Franks, she's also not following the sufficiency, which means that because in order to do either one of those, she has to claim that she lives there. Otherwise, she doesn't have standing.
Yes.
So she's not claiming that she lives there.
Yes.
So now she's just back to okay, the information is insufficient.
Yes, she has to.
Even if that's true, your remedy is here's a revised information.
Yes. But here's the thing. If she admitted to all of that, then she's liable for the 25 grams of cocaine, not just a little bit they found.
That's correct.
Near her.
That's true. So, I didn't say it didn't come with downsides.
Yes, there's a massive downside. If April says, "Oh, I live in the home," which, remember, Nick said she's a friend visiting. Now, that's not all of it, because Kayla also said April was their living nanny, which he kind of forgot that one. And you're just like, what about that part? Because that's very critical to this case, did she live in the house? And I think there's a lot of evidence to show she has lived in the house. And April, and I know Nick thought it was funny to make those jokes of April being on camera in Nick's studio. That's a great way to show, why are you in their house? Because you live there. Why are you in their house at this point? Well, once again, this is not good for April in that regard. So hold on, why is this not pulling up here? Hold on, chat. So this is the complaint from April. It's her complaint here. So the 5th degree possession of drugs, she could face up to 5 years in prison. So the statement of probable cause. And from here we've got, and let's go through the paragraphs here. Where do we see April's name show up at all? So upon entry, they found Kayla and April and 4 juveniles in the home. Kayla and April were located in the master bedroom. Yep. From there, they talk about the times where things were found. The credit cards from Imholt, and they were found on the master bedroom near the nightstand. So that's the credit cards, the snort tube, and the black vial containing cocaine. And that's the little bit they're probably charging her with, if I had to guess, based on everything we could figure out.
Pretty much.
Now, from there, April's purse is located in the hallway outside the master bedroom, leading to the attached bathroom. Pomplin met with Nick Rekieta. Nick Rekieta indicated that April was visiting. Mm-hmm. Now, it's interesting because...
Is it possible to charge both Nick and Kayla and April with possession of whatever amount of cocaine was inside that snort tube or vial that were on top of the credit cards at the same time?
Yeah.
Because
they're all in possession. It's all dominion and control. They all have access to it. I mean, Nick already says, so we're just...
So just so I make sure that I've got this right, we can charge Nick with the possession of the drugs in the safe because it's his house. But we can't charge April with possession of the drugs in the safe because it's not her house and there's no evidence.
It's going to be tough. It's going to be tough to show because remember, Nick has said she was at home visiting right here.
Right.
But then you have Kayla saying that Kayla informed CPS that April is the live-in nanny. Now, if you notice, when April's attorney said this thing out, the probable cause statement, that whole thing is not there. Notice he omits that fact.
Yeah, but when it comes down to trial, you're not going to be able to use that because it's hearsay. And Kayla's not going to take the stand. So
Children's Services will be able to say, what were you told?
That's hearsay.
And they are going to be able to say present sense impression, effect on the hearer.
Bullshit.
I mean, there's ways you
what
can
I
get
said
it
to
in.
that. Bullshit is what I said to that.
I get that in present sense impression. While they're at the house.
Bullshit, that's present sense impression. I call shenanigans.
I agree. That is a bit of an issue there. Kayla is gonna, it's gonna be an issue there. If this interview was recorded or the statement was recorded, though, that would be able to be brought in. So it all depends. Okay, so we'll see. I don't disagree with you. That's a bullshit argument. I'm just telling you what they would argue. So that was not included, and prosecutor's going to point that out. That yes, we have other people saying this happened. And those are the statements there. And now what is April's attorney getting to here? So the statute charge requires unlawful possession. But the complaint does not allege a fact to be true. The defendant unlawfully or otherwise possessed illegal drugs. It only says she was a guest at someone else's home when police executed a search warrant and found illegal drugs. That's not exactly what it says, because it says there's a question about whether or not she was a guest or a resident. Because one of the homeowners said she is a guest, one of the homeowners said she's a resident. So I think that's beyond a reason. That's reasonable doubt for April, but this attorney is omitting some things here, I would argue. According to the complaint complains no factual substantiation or probable cause, it must be dismissed. Well, I'm thinking April's statement to CPS would be pretty good in that regard.
April made a statement to CPS?
Yeah, remember, this is the, See, she informed the protection workers that Imholzer live-in nanny.
That's Kayla made the statement, not April.
No, I'm sorry. Oh, I said April. Sorry.
Yeah, I was like...
She wouldn't say that she's live-in nanny. Yeah. So that
April kept her mouth shut.
Yes, she did. She was smart. So they say probable cause exists when an ordinary person of ordinary care and prejudice, viewing the totality of the circumstances objectively, would entertain an honest and strong suspicion that a specific individual has committed a crime. The complaint makes no allegation the defendant possessed any illegal drugs, but merely she was present in the house at the same time. It should be dismissed for lack of probable cause. They got a lot more than her just being in the house. Though. She's as they said, she was in the master bedroom where all the drugs were. Her credit cards were up on the nightstand where they found drugs. And her purse was found in the hallway of the bedroom where all the drugs were. So it's not exactly that. I do agree. She probably has the flimsiest case of everybody.
Yeah, there's a point to be had here.
I don't disagree, but I think it's going to be a very tough road to. It's going to be a long road to hoe for her, and no pun intended. But yes, the Fifth and Sixth Amendments require that the complaint sufficiently apprise the defendant of what they must be prepared to meet. And I would argue the probable cause statement does lay out your credit cards were there. Why were they encrusted in drugs? Why were you in the bedroom full of drugs? Now, they do point out that they are alleging insufficient information. I don't think there is insufficient information. I think there's enough there. At minimum, she's entitled to a bill of particulars. And as we stated, a bill of particulars, it orders the government to clarify the charges with details sufficient for her to understand and respond. So it explains to her in detail what they're articulating and what they hope they can prove. It informs the defendant of the nature of the charge with sufficient precision to enable him to prepare for trial. It minimizes the danger of surprise. And that's the thing, guys. If the prosecutor is going to argue it in the bill of particulars, they can't go off script and run a different way. Part of a bill of particulars is you're kind of nailing down the prosecutor to a theory of their case. Now, normally it's not a big deal because the theory of their case is pretty straightforward or you already understand it. But sometimes you're forcing them to pick a lane and they can't just run to the next lane in the middle of trial. They have to stick with what they've informed you of. Now, they point out that the court may order the government to provide the additional details where the complaint fails to sufficiently apprise the defendant of the charges to enable them to prepare a defense. Once again, I think she knows there's enough there. It's just how strong is the case? You know, the complaint sufficient when the elements of the offense are delineated and the general statement is accompanied by the specific facts constituting the offense. Now, and as this is, guys, just so you understand, again, she is not challenging the warrant because if she were to challenge the warrant, she would have to admit she lived in the home. Mm-hmm. So I know, as Nick was trying to say before, if April challenges the warrant, they win. Well, there's no challenging the warrant. She's only challenging the charges against her. So they point out the defendant's entitled to know what behavior is alleged to constitute the offense he's charged with. And you notice, guys, you're like, wow, this seems like different fonts and things. They point out the time for a motion. Any time during the pendency of a proceeding, an objection may be made to the court's jurisdiction over the offense, or the charging document fails to charge an offense. So for these reasons, they want to challenge it for lack of probable cause. They want to dismiss the charge on the grounds it does not exist probable cause to believe the defendant committed the charges in the complaint. And given the facts disclosed by the record, it is not fair and reasonable to require April to stand trial. To suppress any and all evidence taken as a result of confessions, admissions, or statements in the nature of confessions made by the defendant.